Would you ask Mr. Martin to come back in, please?
Thank you.
All right, Mr. Martin,
Yes,
ready
sir.
to carry on?
Yes, sir.
Thank you very much. Yes, Mr. Millett.
Yes, Mr. Chairman, thank you very much. Mr. Martin, can we now turn, please, to some later correspondence, this time from 2013, at CLG 100005528. Now, this is an email run from March 2013, and if we go to page 2, we can see that there's an email. There's a copy of, well, there's an email from, if we go to page 2, sorry, we need page 2 for this. Yes, thank you very much. And on page 2, you can see an email from Mike Atkins to a large number of recipients, including I think including you, attaching the short supplementary report from David Crowder. And the names in that list will be familiar to many in this inquiry. At the time of the inquest into the deaths, that had started in the January of 2013 and was well underway, wasn't it? As at the 1st of March.
I believe so, yes.
Now, if we go to page 1 of this email run, please, we can see Anthony Bird's email of the 4th of March 2013 in the middle of the screen, which sends the report to you and Stephen Kelly. Yes?
Yes.
Yes. And he says this: I find item E most telling here, both the question and the answer. So if the right panels had been fitted, then one could have expected less in the way of falling debris, which in turn may have limited the starting of fires in the lower flats, which in turn may have meant that the LFB may not have moved its bridgehead lower down the stairs. I think we can see where the MPS are going with this. Now, if we go to the supplementary report which was attached and made its way to you, that is at BRE 405886. And let's look at item E, to which Mr. Bird is referring you. We find that at page 3 in the document. That's BRE 405886. And the first page of that is the BRE letter of the 1st of March 2013 setting out the instructions. And if we go to page 3, at E, it says, if the composite panels had complied with the requirements, is it possible to express a view on whether the ability of debris within flats 65 and 79 to be blown out of those flats and fall into flats below would have been reduced? And you can see the response below that. I'll read it to you. If the composite panels had complied with the requirements set out in David Walker's report, I would have expected them to remain in situ for some time. Given that fires in flats 65 and 79 were not unduly severe, and no more severe than the conditions achieved in the standard furnace used to assess fire resistance, I would have expected the panels to last 30 minutes or more. During that time, I would have expected these panels to act as a physical barrier to burning debris produced within the room. This would have significantly reduced the amount of debris from within the flats which could have been blown out of those flats. Now, I'll show you that. I now want to go back to the email, please, at CLG 100005528, which is your response to Anthony Bird's question based on E that I've just read you, right? And here is your response, also on March the 4th, 6 minutes later. And you say, but the falling debris could have been from the bird netting or some other crap falling out the window. I still think they are over-egging the impact of the panels, although they clearly didn't help matters. Now, first, who is they in that second sentence?
I don't remember the email distinctly, so I can't say for certain who I was referring to. Could have been LFB or the Metropolitan Police, I'm not sure.
Or the BRE or David Walker? I mean,
It could have been, yeah, I'm sorry, I can't remember.
Did you intend that comment to mean in the context of the falling debris which ignited the fires below it, or more broadly?
I think that's what I'm referring to, is the falling debris.
Right. Why did you think that the impact of the panels was being over-egged, in your expression?
It's difficult to remember what I was thinking about this particular email, but I think there had been a lot of focus on those panels when a lot of the issues that occurred in that incident were internal fire spread issues associated with the internal compartmentation. I think that's what I think that's the point I'm making, is that there seemed to be a lot of focus on those panels that had been installed at the time of the refurbishment, when there are other, I think what I consider to be more important at the time, issues with the internal compartmentation in that building.
When had you first formed the view that they, whoever they are, were over-egging, as you put it, the impact of the panels?
I can't remember, I'm sorry.
Had you expressed that view to David Crowder? The BRE?
I can't remember enough detail to be sure what I hadn't said to anybody.
Was it the position that you were very keen to emphasise repeatedly, as we've now seen, that the falling, flaming debris came from the flats rather than parts of the panels themselves?
Well, that was clearly one of the two sources of debris. I didn't have any particular motive in that. It's just it was a point.
Well, you say you didn't have any particular motive in that, but one can detect from the documents I've shown you, perhaps you don't agree, that your position seemed to be one of taking the emphasis away from the effect or impact of the panels and focusing more on the effect of burning debris blowing out of the flats and falling to the flats below and causing secondary fires. Is that fair?
Well, I wasn't trying to detract attention from the panels. I think it was just we were discussing what we thought about the incident.
And there may well have been other complexities and concurrent causes of the incident, but
yes.
Why weren't you really interested to get to the bottom of the relative contribution to the fires in the flats below, the secondary fires in the flats below, which had been made by the panels, as opposed to combustible material from the contents of the flats above?
No, it would have been useful to know, I guess, but it was clear. I think it was impossible to know for sure what material had fallen where and where it had come from.
Well, that may be, but were you not interested for future reference to know whether or not these panels might behave the same way in a later high-rise fire and cause secondary fires below?
In the context of thinking about approved document B, I think at that time I was thinking, well, we've already addressed the potential for burning material to be falling from the wall construction.
Well, we've been through that, Mr. Martin, but think many people would disagree with that, not least because you've still got Class 0 hanging around in diagram 40.
Well, certainly for this building,
Yeah.
what was in those panels was thermal insulation. So that's not a matter of dispute. I fully understand that the question of filler and so on is a contentious matter. I understand that, but here we were looking at insulated panels.
Do you agree with this, that if you look at diagram 40 and you look at the European classification, BS3D2, D2 means that the production of burning droplets is wholly unregulated. Did you know that?
Well, only insofar as if you've got very little that's burning, you'll get very little burning debris.
Well, you'll get a Class B panel burning with D2 droplets. Did you understand that that was either no or very low levels of restriction?
I didn't know that. Whether I was thinking about that at the time, I can't be sure.
No, and similarly, you wouldn't have been thinking about, as it's right, whether Class 0, with its 476 Part 6 and 7 tests, regulated falling burning droplets. Presumably, you would have, if you'd thought about it, you would have realised that those tests did not. Yes.
They didn't control burning droplets, but they tended to reduce the relative combustibility of the materials involved, and therefore you're less likely to have burning material.
Yeah. You see, what I'm really putting to you is, why didn't the Lacknell incident, and what you knew about it by March 2013, the time of the inquest, prompt you to think about whether or not ADB, particularly 12.6, diagram 40 and 12.7, was sufficiently robust to regulate the downward, one of the potential causes of downward fire spread at Lacknell, namely falling burning debris, which could have come, in part, from the panels.
Sorry, can you rephrase the question, Darragh?
Well, I can do. It's a long question.
Or repeat the question.
Yes, why didn't you think about, given what you knew about the contribution that the panels had made to the downward spread of fire through falling debris, why didn't you think at the time, March 2013, about whether or not approved document B was robust enough to regulate it?
I think we would have discussed that, and I think I can't remember the detail of the conclusions that we came to. I think genuinely we thought approved document B was doing enough, the 2006 edition.
Right. Let's move then to the inquest itself. Now, it's right, I think, isn't it, that before giving evidence, as you told us this morning, you were asked by the coroner to provide written answers to a series of questions.
Yes.
And you did that in a witness statement, didn't you?
Yes.
Can we look at it? CLG 30192002, dated the 12th of March 2013. Now, I'm going to ask you, please, to look at page 5 first, because on that page we see that there's a signature above your name. Is that your signature?
Yes.
And above that, there's a statement of truth. I believe that the facts in this statement are true, yes?
Yes.
And if we go back to page 1, please, paragraph 2, you say this: I should make it clear that whilst I'm happy to alert the inquest to the relevant statutory guidance, the Department for Communities and Local Government, the Department, has no authority to give direction on what does or doesn't comply with the building regulations legislation. I have been explicitly asked to address the following points. Who asked you to do that? Was that the coroner?
Yes, there was a written
Right.
a written request. It was very specific.
Right, and did that specificity come as a result of the department telling the coroner that you had no authority and that you would only respond to specific questions?
Not that I recall, no.
Right.
But I can't say for certain. I can't remember the detail of it. I remember that there'd been in the process of the inquest, there'd been some specific issues that had arisen over the interpretation of building regulations, which had, in a way, it was distracting from the work of the inquest, and between the department and the inquest, we concluded that we might be able to resolve that quickly to allow the inquest to continue its work.
Paragraph 3 on page 2, you say this: I've referred to the 2000 edition of approved document B, ADB, incorporating the 2002 amendments, which I understand is relevant to the work in question. Were you told that, or did you assume it?
I'm not sure where I got that information from.
Right. So we've seen that in 2011 you corresponded on the basis of the 2006 version, but here you're now saying that you're referring to the 2000 edition, and indeed I think it's right, because you told us so this morning, that you realised that it was the 2000 or 2002 edition that was relevant to the Lacknell refurbishment at quite an early stage, in 2009.
I believe so, yes.
Yes. Now, I just want to pick up on a number of matters with you relating to points C, D and E. Can we deal with C, please? That's at page 4. And at page 4, paragraph 16, under the heading, which panels were required to be class 0, you say, paragraph 7 above explains the relevant guidance. It is only those parts of the external surfaces that are themselves above 18 metres in height that have to be constructed of class 0 material. Glass is such a material. Now, if we go back to page 2 and look at paragraph 7 next, you say this: in section 13, titled Construction of External Walls, pages 89 to 91, paragraph 13.2, page 89, and this is the 2002 edition, I should say. Page 89 introduces the principle of limiting the combustibility of external walls of tall buildings to reduce the danger from fire spread up the face of the building. This relates to the need to meet class 0 for walls above 18 metres in height and has no bearing on fire resistance. Class 0 refers to the reaction to fire of the materials used in the construction of the external surface. Now, why do you say here that the principle of limiting the combustibility of external walls of tall buildings relates to the need to meet class 0?
I think that's the point that we've discussed a few times now, is that in this context I'm using the term combustibility to talk about the general concept of how there's a sliding scale of combustibility, whereas I appreciate that the inquiry thinks it's more of a binary point.
Well, never mind what the inquiry thinks or not. Let's get to the facts. I think you agree with me that class 0 itself, which is based on passing 2 parts of 476, BS 476, is not a combustibility test, is it?
I don't know how many times I have to disagree with you on this point.
Right.
There isn't a combustibility test. There's a non-combustibility test, and then there's the question of measuring how combustible something is. So the concept of combustibility is a sliding scale, and Class O is one of a range of different classifications that attempt to classify how combustible something is.
But I think clearly my questions aren't really getting through. Do you accept that class 0 isn't a combustibility test and doesn't tell you very much about combustibility? What it tells you about is fire propagation, which is the part 6 test, and surface spread of flame, which is the part 7 test. Yes?
Which relate to the combustibility of a material.
Well, in what sense do they relate to the combustibility of the material as understood in approved document B?
So in this context, the word combustibility is if you like, shorthand to saying reaction to fire. So it's talking about a sliding scale of combustibility rather than a binary, is something combustible or not.
Right. And that, with great respect to you, is what you told us a number of times already in your evidence.
Yes.
My question is, did you explain that to the coroner? Did you explain to her that you were using the word combustibility as shorthand for reaction to fire?
I think if you read that paragraph in whole, in completeness, I don't think there's any uncertainty about that. Perhaps you think otherwise, but it says that the last sentence also refers to the reaction to fire of the materials used in the construction of the external surface, which I think is correct.
Let's look at page 4, paragraph 17. You can see the heading, which panels were required to be class 0. And you say this, well, you can see the question. Well, let me just show you para 16, first of all, just under the heading. Paragraph 7 above explains the relevant guidance. It is only those parts of the external surfaces that are themselves above 18 metres in height that have to be constructed of class 0 material. Glass is such a material. And then the question at D, the extent to which the guidance on any of these points has been updated or clarified in versions of approved document B subsequent to the 2000 version. That's the question. And your answer at 17 is this. The guidance which supports Part B fire safety of the building regulations, namely approved document B fire safety, volume 2, buildings other than dwelling houses, was last amended in 2006, and the amendments came into effect in April 2007. With particular reference to the matters in question, guidance on the construction of external walls was clarified in the 2006 amendments to avoid ambiguity. The layout of the paragraphs and the wording were presented in a more definitive way, with particular reference to paragraphs 13.5, 13.7 in the 2000 version, and paragraphs 12.5 to 9 in the 2006 version of ADB. Now, what specifically were you referring to there when you said that the guidance on the construction of external walls was clarified to avoid ambiguity?
I think the way we'd reconstructed those paragraphs to sit under a general heading of construction of external walls, or external wall construction. I can't remember the exact language.
I see. So that's... I see. That's the layout, is it? A reference to the change in the layout that we saw when we compared the 2002 edition with the 2006 edition.
Yeah, I think what we were trying to do was set out that that when you're looking at the external wall construction, it's a combination of factors.
And what was the ambiguity that you were seeking to avoid by those amendments that you were telling the coroner here?
At that time, we thought we'd made it a lot clearer.
But you referred to ambiguity. What was the ambiguity?
I don't think I was referring to anything specifically.
Right.
If I was, I don't remember.
When you say there that the layout of the paragraphs and wording were presented in a more definitive way, what did that mean?
I think the same as what I've just said. At that time, we felt that we'd made that guidance much better.
By structural changes, I think. Is that right?
And some of the other textual changes that we'd made as well.
Well, you say that, and that's my next question. Were you intending to refer in part to the changes in wording of the headings to certain paragraphs?
I think so. I can't remember what I was specifically thinking of at the time I wrote this, but I know that at the time of writing, we thought we'd made that guidance better.
Right. Can you tell us why there's no reference here to the introduction of the words filler, material, etc., into the text of what became 12.7?
I guess looking at the text I've used here and the question I've been asked at that time, it was, where has this guidance been changed? So I was explaining the structure had been changed and pointing the inquest at the specific paragraphs.
Well, that doesn't really answer the question, does it? Why didn't you point the coroner squarely to the change that you had made as a result of the Edge fire, which addressed the use of combustible foam insulation material in an external wall panel, and tell her that the word filler material, etc., was intended to address that very problem by way of an amendment?
I probably wasn't thinking about the word filler because it wasn't particularly relevant to the panels that were being discussed for the Lackner House inquest, I guess. And as I say, I'm pointing out the relevant paragraphs. I would imagine that the counsel to the inquest compared the text in both paragraphs.
Well, I don't... This morning, I think you told us... I'm sorry, Mr. Martin, if I'm trying your patience, but this morning you told us...
I'm tired. I'm doing my best to... If I seem aggravated, it's because I'm tired, and I apologise.
All right. Well, let's take it slowly. You told us this morning, correct me if I'm wrong, that one of the important, if not the important amendment in the 2006 approved document was the introduction of the word filler, which restricted the core of an external wall panel to a material of limited combustibility, which was a critical difference.
Amongst other things, yes.
Yes, absolutely. Now the question, therefore, is: well, given that critical change had made the difference in the context of the Lackner fire, why not bring that very change to the attention of the coroner under paragraph 17?
Because it didn't make the difference for the Lackner fire. The Lackner panels were insulated panels, so the question was whether it controlled insulation or not, and that was very clear.
Well, why not tell her that the removal of the qualification relating to ventilated cavities and the broadening of the restriction to material of limited combustibility had the effect of improving the guidance?
I think that might have been a more helpful thing to do at the time. I guess we didn't think of it. I've tried to point... Looking at the... I mean, I can't remember what was going through my head specifically at the point I was writing this. I think what I was trying to do was explain in general terms that we had revisited that text and this was the new text.
Mr. Martin, I think the point that really you're being asked to consider is, although you have identified in this paragraph the fact that the previous paragraphs 13.5 to 13.7 had been rewritten, you don't explain the respects in which they've been changed. And do you think that would have been a useful thing to do?
I think in hindsight it would have been a useful thing to do so, yes. I honestly thought I was giving a constructive and helpful answer at the time. Being asked that question, I guess I could have gone into more detail about the exact changes. Whether that would have been helpful or not, I'm not sure.
Yeah, all right, thank you.
Were you trying to avoid scrutiny by the coroner of the word filler, material, etc., because you knew it was less than clear, and as you told us in your own evidence here, were unhappy with it in the circumstances in which it had come into ADB in 2006?
I don't think that's what I was thinking, no.
Why is there no reference here to the removal of the words, the removal of the caveat that we saw earlier in the 2000 and 2002 edition, that the last part of the second sentence of what was then paragraph 13.7?
I thought this was a helpful and constructive answer to the question at the time. I guess I could have listed all of the textual changes, but it probably would have been easier just to give the inquest the two sets of paragraphs, which is what I've done.
When you were preparing this witness statement, did you have at your elbow the text of section 12 of ADB 2006 and compare it with the text in section 13 of the 2002 edition?
Well, I would have had access to it, yes. It would have been on I think both copies would have been on my desk at the time.
Yes. Didn't you notice before you made your comments here on the more definitive layout that the heading of paragraph 12.7 was intended to apply not only to insulation but to all products, and draw that to the coroner's attention?
I think at the time I was thinking about insulated panels because that's what were being used. Those were the products that had been used at Lakanal House.
When you say insulated panels, do you mean? But let's be clear about terminology. Do you mean sandwich panels?
They were effectively quite narrow sandwich panels.
Yes. So how are they different from the panels at the edge?
They were being used for their thermal properties, whereas for the edge we suspected that they weren't being used for their thermal properties and therefore they weren't thermal insulation. Whereas the panels for Lakanal House were acting as the separation between the outside air and the inside air, so the thermal properties were why the insulation was there.
So why not bring that fact to the coroner's attention and just say in simple terms that approved document B in 2006 was updated and clarified so as to tighten the restriction to ensure that the panels which were used at Lakanal were no longer compliant? Why not say that?
Well, less compliant, I suppose, because they weren't compliant anyway, because they weren't Class O, and that was the question that we were mostly focused on, I guess. In hindsight, I could and probably should have mentioned the insulation.
Yes. Yes. Now, you knew by March 2013 that the composite panels at Lakanal were comprised of a Trespa high-pressure laminate, yes? As well as an unidentified foam core.
I think so, yes.
Yes. Did it occur to you at that time that it might be appropriate to flag to the coroner the potential relevance of the combustibility, and I mean that in its technical sense, of the composite panels?
I don't think it did at the time.
Why is that?
I'm not. I think I was focused on the specific questions rather than the generality of the issue, which may have been wrong. I'm not sure. I think I can't. I have a feeling that I was instructed to answer the specific questions directly without expressing any other points. I can't remember for certain now.
Right. Let's look at the next question at the bottom of page 4. The extent to which there is scope for further clarification on any of these points. Answer. The department has no immediate plans to update the guidance contained in ADB. However, a new style guide has been adopted for approved documents which is designed to make them easier to follow and incorporates the principles of plain English. As and when ADB is reviewed again, this new style would be applied. Now, looking at that now, can you help us? How did that actually answer the question that the coroner had posed to you?
I think it was setting out the department's plans at the time. I suppose ultimately there's always the scope to change something if the Secretary of State agrees that we should change it. Perhaps I took that as being obvious and didn't need to be said. I don't know. At the time, I thought that I honestly thought this was a helpful response at the time I drafted it.
But you see, the question was the extent to which there was scope for further clarification on any of these points. Did you not understand that to be a question on whether the department thought that in the light of what it now knew about the Lakanal House incident, notwithstanding any updated or updates or clarifications in approved documents since 2000, there was scope for further clarification? Did you not understand the question in that way?
I don't think I did read it in that way, but I can't be sure. This is a long time ago. I honestly can't remember exactly what I was thinking. I do remember taking what I thought was a lot of care over this, and you know, when you read back these things years later forensically, you do look at it and think could have said more about X or Y. At the time, I honestly thought I was providing a helpful answer to help resolve a problem that happened with the inquest.
Right. Did you, when you signed this statement, did you not recall the correspondence that you'd had with Daniel Turner of Ipswich Borough Council only 2 months before, the January of 2013, and his question and the resulting chat in the office? It was the Cool Beans emails. Remember those?
I don't remember thinking about them at the time, but I honestly can't remember what I was thinking. I answered the specific questions to the best of my ability at the time, I thought.
Right.
Forensically, yes, there are things you can look at and say there could have been more detail in some of these paragraphs. I think I can only accept that.
Did somebody tell you to keep your evidence as narrow and as vague as possible when answering the coroner's questions?
Certainly no one told me to be vague.
Well, general then. Did somebody tell you to answer these questions in as generic and as general a way as possible without condescending to any details?
No, I don't think anyone told me to do that. I think our intention was to be as helpful as possible to the inquiry. I think the advice I was given was to address only the questions I'd been asked. And I think that was to some extent the nature of the way my evidence... I'm not an expert in these matters, but I was described as an evidence to the fact, which meant that I wasn't to express any opinions. So I think that was one of the reasons why I was advised to focus very specifically on the questions I'd been asked.
Yes, indeed. Focusing very specifically on the questions you've been asked, but in relation to the answers, why were you as generic and as general as this, instead of condescending to particular details about, for example, the questions which had arisen about the meaning and scope of 12.7, which we've already explored, as they stood at March 2013?
I don't think... I don't remember making a conscious decision not to include those things. As I say, I thought I was giving a constructive and helpful answer to the inquest, focused on the questions they'd asked me, and I guess relevant to this particular construction they were focused on.
Let's turn next to your oral evidence.
Well, before we leave question E, can I just invite your comment on this? What I think you were asked in question E is, could ADB be made clearer in certain respects? And that invites a preliminary response, yes or no, before you go on to say whether the department has any plans to do anything. Do you see now what is really the point you're being asked to?
I think so, sir. I think there's at least three ways of reading that question. I don't think I'd read it in the way you're suggesting, but I can see that is one possible interpretation. I don't remember thinking about this. Compared to the other questions in this statement, I probably didn't think this one was as significant. Perhaps that was wrong.
Well, it's a slightly difficult question if you think you're not entitled to express any form of opinion, because in a way it's inviting you to do that. But if you didn't read it in that way, then obviously your answer is going to reflect the way in which you read it.
I think so, sir. Yeah.
All right. Well, perhaps
I'm not sure if I can come up with a better answer than the one I'd given there. I mean, there's always scope to improve some text, I guess. And if the department or the Secretary of State had decided to change text, then obviously there would have been scope to do so. I think still at the time, I think we thought it was we'd given good guidance.
Yeah. All right. Thank you very much.
Just to be clear on that last answer, Did you read the word scope as meaning opportunity, or did you read the word scope meaning need? They're different.
I can't say what I thought at the time. I'm reading it now thinking it means opportunity, but I can see that perhaps you could read it different ways.
Did you think of going back to the coroner and asking for clarification on what you regarded at the time as an ambiguity in her question?
I don't think I realised that I didn't think it was an ambiguity at the time. I think I probably would have done.
Well, let's turn to your oral evidence. Now, you'll recall that covered a full day, yes? Do you remember that?
Yes.
Now, we're obviously not going to go through all of it, but I just want to concentrate on two specific aspects of your evidence on the day. INQ 3015070, please. Now, this is the 13th of March 2013, the day after you signed your statement on the 12th. And that's the first page where you're introduced by Mr. Maxwell Scott of counsel to the inquest. And if we go, please, to page 51 in the transcript, we can see some questions and answers. The context, so you're clear, was a series of questions from counsel about fire resistance of balcony panels, and you had explained your view that none was required. And if we pick it up at line 11, you were asked this question. On that footing, the fitting of panels which caught fire within 1 minute and burnt through within 4.5 minutes would be what? Perfectly acceptable in accordance with approved document B? And your answer at line 15 is, well, if they caught fire, they probably weren't class 0. Now that answer was, do you accept, inaccurate and wholly misleading, wasn't it?
I don't think it's wholly misleading, but I think it's fair to say that it wasn't as precise an answer as I could have given. I think probably over the years I've got a better understanding of some of the limitations of the Class O classification, which I might not have fully understood then.
And it gives a clear impression, doesn't it, that something which is class 0 won't catch fire, doesn't it?
And I think to some extent I thought that was true.
How could you have thought that was true?
Because things that are class 0 are harder to ignite than other things.
What was it about the limitations of class 0 that you didn't understand when you were giving evidence to the coroner in March 2013?
I think I probably had greater confidence in it as a classification than perhaps I do now.
But what was it as a matter of technical ingredients that you didn't understand when you gave your answer, well, if they caught fire, they probably weren't class 0?
I think I recognise now that a class 0 component could still eventually be ignited. We'd looked at the question of surfaces and components beneath that, and so I think it was an imprecise answer to the question.
And does that imprecision belie the fact that in reality you were conflating class 0 and the concept of limited or non-combustible?
I don't think so. I think class 0 materials, and unless they're one of these materials which has, if you like, circumvented the intention of the test through very thin layers of foil, tend to be quite difficult to ignite. That's why class 0 was introduced into the building regulations for external walls in the first place.
Just help me with this. Does it suggest that the surface is difficult to ignite, or that once ignited it burns rather slowly?
It's probably a combination of those factors.
Well, I'm sorry to interrupt you, but doesn't the test suggest it's concerned with the speed at which it burns and, of course, the heat generated by the burning, rather than the difficulty in the initial ignition?
I suppose the Part 7 test, the surface spread of flame test, to some extent is linked to how easy a material is to ignite. I'm probably stretching my area of expertise, sir, but the harder something is to ignite, the slower flames are likely to spread along its surface. That seems reasonable to me. And the fire propagation test adds a level of looking at how much heat is released when it does that. So perhaps it was an ill-considered answer at the time, I think, but I think it's fair to say that there's a link to how readily something will ignite to Class O, and I think that's right. I'm sure there are fire scientists that might disagree with me, but that was definitely my understanding then, and I think it still is now.
Thank you. Right. Yes, Mr.
Well, let's just pick up that theme while we're on it. Can we go to page 72, please? Line 21. At line 21, you're asked this question. So Class 0 doesn't necessarily mean a surface that won't ignite. It means one that has limits as to the time and the rate at which fire should spread. Is that a fair comment? Answer at line 25. Yes, it will burn, just not very much. Now, again, that's not an accurate answer either, is it?
I think it's what I was just trying to say. I think that was I don't know how else to express it. Something with a low surface spread of flame and low fire propagation is going to burn less than something that's got high values on those tests.
Well, now, we've been through the evidence on the CC 1924 tests done in 2001 as the preparatory work funded by government leading up to BR 135, published by you and Sarah Colwell in 2003. You were aware, were you not, by March 2013, a decade on, more, that a product achieving Class 0 could suffer extensive burning?
Don't think that was in my mind at the time.
Well, why did you give this answer? It will burn, just not very much.
I believed that was the right answer.
Why did you believe it was the right answer?
I saw Class O as being on the sliding scale of combustibility, not as good as material of limited combustibility, but better than Class 1.
The Class 0 isn't on the scale of sliding scale of combustibility, is it?
Well, I think it is.
Do you accept, or did you remember, that there is a British standard national class test for limited combustibility, namely 476 Part 11? That's about combustibility, and it's a different test.
Well, it's got combustibility in the title. That doesn't mean to say that the other tests don't. I still take the view that the term combustibility is a general term.
So you go back to your answer you gave us a number of times now this
Yes.
morning, which is you use the word combustibility as a shorthand for reaction to fire, and lump within it Class 0.
Yes.
Yeah. Going back to Class 0 and its tendency to burn, had you no thought to the UAE fires that had occurred the year before, for example, which had used ACM external wall panels?
I don't think I made that connection at the time. I probably should have done.
And what about making the connection with the evidence given to the Select Committee in the summer of 1999 and the Select Committee's report and recommendation on the 14th of December 1999 about Class 0? Had you forgotten that?
Well, I wasn't directly involved in that. Perhaps if I'd been more involved in that, I'd have given this more thought.
At what stage, well, let me put it slightly differently. I think it's right, isn't it, that at no stage during your evidence did you say that if Lacknell House had been refurbished in or after 2007, then the PUR foam in the window panels would have been non-compliant with the approved document because they were combustible and not of limited combustibility. You didn't say that anywhere, as we can see.
No, I think, as I say, I was addressing quite specific questions at the time.
But why did you not, at least in the course of your answers, alert the coroner to that fact?
I think I was focused on just answering those specific questions. Perhaps I should have raised that, but at that time that wasn't in my mind. I think the main issue in question really related to the question of fire resistance, and I think I was more focused on that at the time.
But Class Naught isn't about fire resistance. It's about, as you say, combustibility, which means reaction to fire. And these questions are about reaction to fire.
Yes.
So why not just say, if this refurb had been done after 2007, then these panels couldn't have been used?
I think because we were talking about whether or not they should have been Class O. That was the question that had arisen in the inquest, and I think I was focused on that specific question. That's an explanation, not an excuse. I think I should have mentioned the insulation. I'm not sure why I didn't.
Now, you didn't raise the possibility, which I would suggest to you was an obvious possibility, that the combustible nature of either the Trespa HPL or the unidentified foam insulation, or both together as a composite panel, may have been significant factors in the external fire spread. We don't see that.
No, I mean I wasn't there to give general advice on the fire. That was for the experts that were advising the inquest.
Right. Do you say you didn't realise the relevance of that matter at the time?
Well, it wasn't relevant to the specific questions I was being asked.
Right. Now let's go back, please, to page 43 in the transcript. And on page 43 we have line 13, where there's the question as follows. Given that there were so many wrong analyses by people who were applying their mind to approved document B, do you agree that it might be desirable if approved document B could be revisited and reworked so that it was clearer to those who had to apply it as to what the conclusions ought to be? And your answer is this, at line 19. That's an interesting point. Trying to make these documents simple to use is a challenge. Designing buildings is a complex subject. My own experience from dealing with the inquiries that I get is generally most professionals in the industry seem to cope with applying the guidance without too much difficulty. If it was generating the kind of problems that you might imply from the discussions that you've had here, I think I would know about it, and I don't. What experience were you referring to there?
I think that, again, from memory, most of the contentious issues that were cropping up here related to the question as to whether or not the walls needed to have fire resistance or not. And my experience is that people understood those provisions. So that was the point I was making, is if lots of people were having that problem, I would have thought that would have come to my attention, and at that time I didn't think we were getting a lot of inquiries on those issues.
Who are the professionals that you're referring to here?
Various people that I would bump into and talk to on the telephone.
Right. Why do you say with such confidence that if the clarity of the guidance was generating the kinds of problems the coroner was referring to, then you say, I think I would know about it? How would you know about it?
By the number of inquiries that we had been receiving, and at that point we weren't getting that many. Some of the questions on external wall construction probably manifested themselves a year or so later, I think.
Right. Moving to page 45 then, line 5. You say, there's a question actually. It's quite a longish question. Let's stick with the answer at line 5. I think the idea that you could have no ambiguities, I think is, and then you go on, a nice objective. I'd be surprised if it's possible, question, but nevertheless there could be some reworking, couldn't there, to increase clarity? And then you say any document can be improved. Yeah. Now, do you agree that, at least from the face of the transcript, that this is quite a defensive answer in the face of criticisms of the approved document?
I suppose I can't remember what I was thinking at the time. I think I know the coroner was frustrated with some of the confusion that had occurred during the inquest. Some of that was probably a fair criticism to say the approved document could be improved, but I think a lot of that also was the nature of the way various counsels that were at the inquest were pursuing particular lines of argument, and it's not a very constructive way to review a document with in that kind of environment. So I think that's the point I was trying to make there. Is that in practice, I mean, certainly the issue of arguing that the external wall should all have 2 hours fire resistance, that wasn't something that was occurring on a daily basis.
Mr. Millett, I take it this is a question which began on the previous page, was put by Mr. Maxwell Scott, is that right?
It is.
And did in his question, did he
let's show
identify specific respects in which he was suggesting this document might be clarified?
That is a good question, and the answer is no, not really. But there's a long run up to this, which starts a number of pages earlier, which is about 120-minute fire resistance to the outside surfaces of Lacknell House, and thinking that was wrong. That was one of the suggestions. And there are a number of contentions here which are nothing to do with reaction to fire.
No, well, I'm not inviting you to read a lot of material.
Well, that's why I was trying to avoid it.
I understand the difficulty.
Yes.
It's just that what the witnesses said is, well, a sort of generalised suggestion that the document could be improved is one with which it's quite hard to quarrel in relation to any document, but not very helpful if one's actually trying to focus on a specific area.
No, but I think the best thing I can do to try to answer your question is to start at page 44, line 21. And
that will give us the lead in.
Well, it will give you the lead in.
Yes.
But I'm not sure it'll elucidate much more.
No, all right, thank
great
you.
respect to Mr. Maxwell Scott. And at 44, understood, he says, well, it's a matter for our coroner, who has the power to make recommendations for the future. And we've heard what you've said about the introduction of plain English and designing this document, so instead of being 2 columns, it's 1 column. But it might be something that the coroner might have in mind as recommending that this document really should be re-edited in order that there can be no ambiguities of this kind in the future. What would you say to that? And then I've read to you the exchange after that.
Yes, thank you.
Now, I'd like to go to page 78, please, if we can, line 24. There, at line 24, you say, and I should certainly take you to the coroner's question at line 5 first. Up the screen, can we scroll up, please, to line 5? The coroner asks you this. It seems to me that if you need a specialist engineer to take you through a document in order to get straightforward answers to fairly basic, straightforward questions, then the guidance document isn't really doing what it says on the tin, is it? And you say, I think that might be a little unfair. What you tend to find is that different contractors and different manufacturers and other people involved in the process learn the bit of the building regulations that affect the kind of thing they do. So in practice, a lot of them will probably never directly refer to the approved document. That's one of the benefits of schemes like the Fencer scheme, for instance, where common work is replacement of windows. And rather than the members of that scheme clawing their way through the building regulation, they'll use the guidance that they're given by the scheme provider, which is explaining how to apply the building regulations to the kind of work they do. So my experience is it's not as big a problem as it appears, but I do recognise that the approved document could always be easier to read. The challenge with a document like this is it could well end up being a library full of paper if you tried to cover every eventuality. So it's a balance between those things, and then the debate continues between you and the coroner. Now, when you say there that, in my experience, it's not as big a problem as it appears, but I recognise that the approved document could always be easier to read. What was not as big a problem as it appears?
I think the general. I'm pretty sure at this point we were talking about the generalities of the approved document. There'd been a number of issues. I think one of the things that the coroner was frustrated with, or had become an issue, was that the Leghorn House was of a design that was quite popular at the time it was built. It's what's known as a balcony approach block. So part of the circulation and therefore the escape routes from the flats was via the external balconies, which was quite common, I guess, 30s through to 50s or something like that. But had become unpopular in more modern buildings. And fire safety guidance on that type of building wasn't included in approved document B. It wouldn't have been BS 9991 then, it would have been its predecessor, which I think was BS 5588. I think it was part 1. Understandably, there was a frustration that you needed to refer out to multiple documents to get the answer to what I can understand why the coroner regarded as a straightforward question. And that was the question, I think, about whether the panels needed fire resistance to protect the escape routes, which I think was where there was some. I think that's where the surveyor that the coroner had appointed to advise on building regulations had made a mistake in his report, because that code only requires fire resistance to the escape routes where they're only in a single direction. I'm sorry, it's a really complicated answer, but I know that was one of the frustrations, was that the document cross-referenced to other publications, which is frustrating if you're trying to look at an existing building and decide whether or not it met the rules. If the rules are distributed over multiple documents, that's frustrating. I recognise that. I had to do that myself. But you'd end up with a library full of paper if you put all the information in one document, and that's the challenge you have.
Right. Now let's go to page 80. And if we go, please, to line 2. She says this: well, I think the exercise we've seen in these calls indicates that it isn't a straightforward exercise. In fact, it's quite Byzantine, isn't it? Answer: I'm probably not the right person to ask. I've worked with it for a long period of time, which to me is why it seems very straightforward, which is why we went through the process I've described in the lead up to the 2006 changes, to ask people who do use it what they think, and the feedback I get is that people don't have a problem with it. Were you not effectively telling the coroner there that you were too close to the document to be able to assess in any impartial way whether or not its content was sufficiently clear to its intended users?
I think to some extent, that is what I'm saying. Yeah. Yes, and that's why it's important if you are carrying out a review of something like that you do include the readership.
Yes, and Mr. Harrell described you, when he gave his evidence on day 243, as possibly snowblind, his word, as a consequence of having worked very closely with the approved document B for a number of years. Was that a fair way of describing you at the time?
I'm not sure if I'm the person to judge.
No,
but what people maybe that it may be, in looking at what's happened over the last few years, maybe that's fair.
But the better question perhaps is that the message you were trying to impart to the coroner yourself here?
I think I'm also trying to impart to the coroner that that's exactly the exercise that we'd just been through with the 2006 review, is that in order to ensure that it was as clear as we could get it, we had gone to quite some length to speak to the readership of Approved Document B and identify those things that needed improvement. And we would have gone through the same exercise again with the next review. And I'm convinced that's the right way to do it. It's been clear to me that as I moved from working in building control to working in policy, is that you very quickly lose touch with how the thing's working in practice. And given that we didn't have a regular monitoring mechanism, when you came to do a review, an important part of that review would be to start with a survey of users and an interaction with users. So I think I'm trying to say to the coroner that's exactly the exercise we've just been through.
Right. Why did you not mention to the coroner your reaction of horror to Adrian Prest's complete misunderstanding of the fundamental requirements in B4, which we looked at earlier?
I guess I could have talked about all sorts of things. This was the first time I'd been in a coroner's court as a witness. I can't say that it was something that I was comfortable with, and I was probably answering as helpfully as I could be, but I'm probably not as extensively as I could have done.
Well, it's a question of impression. When you say most people don't have a problem with it, you had quite recent experience of a senior head of building control who had checked with another senior colleague and who completely misunderstood one of the functional requirements. Was that not something that you had recalled when telling the coroner that most people don't have a problem with it?
If I'd have recorded it, I would have mentioned it, but I clearly I didn't.
And similarly, when you had dealt with Daniel Turner at Ipswich Borough Council in the January of that year, you yourself had told him that you needed to read the approved document provision on external fire spread 2 or 3 times to work out what they mean. Had you forgotten that exchange?
I don't think it was in my mind. I didn't think that was particularly significant. If you're thinking that someone can write a book that tells you how to design every conceivable building in very simple terms, then that's not possible. And I'm confident that will always be the case.
Yes. But I'm quite sure you didn't understand that the coroner was asking for a cast-iron 100% hit rate. For anybody who opened ADB to understand it pellucidly clearly. Surely.
Yeah, and I think what I'm saying here is I thought most people understood it most of the time, and that's reasonable, but you can always improve it.
Now, at page 80, line 12, the coroner says this: I just query whether applying plain English principles or having 1 column on a page rather than 2 columns on a page will actually resolve the sort of difficulty we've been seeing in this court. Answer: the exercise that the document we've most recently applied this to, is the document dealing with the design of stairs, and we restructured the guidance as well to make it easier to follow. But it's difficult. Fire protection in buildings is a complicated subject, and I don't think you can stop that being the case. Coroner: but it's such an important subject that it's one that ought to be accessible to the people who have to use this document. Answer, at line 25, my experience is that it is. And your evidence ended at that point. Now, it's clear, I would invite you to accept that the coroner wasn't talking about the need to use plain English or shuffling paragraphs around, was she?
No, and no. The exercise that we'd carried out on this new style guide that we'd adopted went a lot further than just using plain English and changing the format of the document. But it's really difficult work to do, and something that at that time we were planning to work our way through all of the approved documents and bring them into that new style. It was something that we thought was the right thing to do. And that's what we were trying to do, was trying to adopt a better approach to the way approved documents were produced.
I'm looking at the evidence. Can you help us to understand what it was in March 2013 when you were addressing the questions from the coroner that led you to be able to state with unassailable confidence that the technical content of the approved document on external fire spread was sufficiently clear to its users?
I don't think I'm using unassailable confidence. I think that's stretching the point a bit. I've acknowledged that the guidance could be improved and that we were planning to improve it, which I guess is the contrary to what you've just said.
Well, let me put the question.
Most people in the sector, firmly believed, understood the principles that approved document B was drafted around.
Right. Well,
perhaps I was wrong.
Mr. Martin, since you take issue with the way I put the question, let me put it more neutrally. Question at line 22, but it's such an important subject that it's one that ought to be accessible to the people who have to use this document. Answer, my experience is that it is. Can you help us what it was at that time that led you to say that about external fire spread?
It wasn't about external fire spread. We were talking generally about the entire approved document, and I firmly believed that the 2006 edition was better than the previous editions, and the people that I met and discussed fire precautions with understood the principles that was in the approved document. So I think that's what I'm trying to say there.
And what I'm really trying to get you to accept, and maybe you don't accept it, is that your experience actually included some instances which were relevant qualifications to the experience that you're telling the coroner there.
In that, from time to time, I'd speak to people that didn't understand it. I suppose that's true. But as I said, I think you've just agreed to yourself, is you're never going to get 100% success rate.
Mr. Chairman, is that a convenient moment?
Yes, I think it is. Thank you very much. Well, Mr. Martin, we'll have the afternoon break at this point. We'll stop now. We'll come back, please, at 25 to 4. And again, please don't talk to anyone about your evidence or anything relating to it while you're out. All right? Thank you very much. Thank you very much, Mr. Millett. 25 to 4, please. Would you ask Mr. Martin to come back in, please? Right, Mr. Martin, ready to carry on?
Yes, sir.
Thank you very much. Yes, Mr. Millett?
Thank you, Mr. Chairman. Mr. Martin, we're now going to go to the Rule 43 recommendations that the coroner sent, making recommendations under Rule 43. Can we go, please, to CLG 401870? And you can see there that the letters dated the 28th of March 2013 sent to the Right Honourable Eric Pickles MP, who was the Secretary of State for Communities and Local Government at the time. And it starts, Dear Secretary of State, Lacknell House Fire, 3rd July 2009. Can we take it that you read this letter in full at the time?
Yes.
In detail and with care?
Yes.
Yes. Can we go to page 3? And I want to focus on the fourth recommendation under the second heading, Building Regulations and Approved Document B. Now, there's quite a lot of text there, but can I take it that you're familiar with it?
Yes.
Yes. And if you look at the recommendations under the first text, it says, it is recommended that your department review ADB to ensure that it, first bullet, provides clear guidance in relation to Regulation B4 of the building regulations, with particular regard to the spread of fire over the external envelope of the building and the circumstances in which attention should be paid to whether proposed work might reduce existing fire protection. And then second bullet is expressed in words and adopts a format which are intelligible to the wide range of people and bodies engaged in construction, maintenance and refurbishment of buildings, and not just to professionals who may already have a depth of knowledge of building regulations and building control matters, and then provides guidance which is of assistance to those involved in maintenance or refurbishment of older housing stock and not those only those engaged in design and construction of new buildings. Now, if we look at the text that follows the words, it is recommended, I think we can agree, can't we? There are three distinct parts to it, yes?
Yes.
The coroner asks that the approved document be reviewed and the consideration be given to three separate matters, and let's see if we can tick them off together. The first is to provide clear guidance in relation to B4, and in particular external fire spread. Yes?
Yes.
Yes. And the second recommendation was to ensure that the language and format of the guidance were intelligible to the wide range of users of the document. Yes?
Yes.
Yes. And then thirdly, to ensure that the guidance assisted those refurbishing older housing stock as well as those constructing new buildings. Yes?
Yes.
Yes, thank you. Now, if we go to your statement, please, page 8, paragraph 23. You say at paragraph 23 there as follows, recommendations from coroners are always treated as a high priority. My recollection is that the Lacknell House Rule 43 letter was taken very seriously by the department and by the ministers involved. What is it about your recollection of the treatment of this particular Rule 43 letter that leads you to say that it was taken very seriously by the department?
A lot of people were involved in considering the recommendations and the response to it.
Okay.
And all the way up the department. And certainly I was aware of directors being involved in discussions about that, and I presume directors general and above would have been involved as well, but I wouldn't have known that.
All right. Let's go to HOM 30047478. This is a series of emails between you and various officials in and outside the department, including Louise Upton in April 2013. And we don't need to read it all. If we go to page 2, we can see an email sent by Mary Marshall on Monday, the 15th of April 2013 at 6:45 p.m. To Louise Upton and Brian Lee. Subject, redraft Lacknell House Rule 43 submission, FSO/housing. Now, you're not copied into that, but we can see from it that the response to the coroner's recommendation from the housing division of MHCLG is being discussed there. That is in summary what's happening, yes?
Okay.
Now, if we go to the bottom of page 1 of this email run, we see that Louise Upton forwards this email chain to you the following morning, April the 16th. And she says, housing comments attached, do you think we should firm their mettle to put proper advice to Mark Prisk on the sprinkler issue? I'm losing the will to live. You see that?
Yes.
And then your response, moving up the next email in the chain to page 1, is as follows. We will need to consider, quotes unquotes, isn't a recommendation. I guess there are two options. Try and actively raise awareness of the coroner's thoughts with all landlords, a big and essentially pointless task. Second bullet point, tell the coroner we've already raised this with social landlords, but for others it's up to them, and most will be aware of the case, so we don't plan to do anything. Bracket, we only have a duty to respond to the coroner, not kiss her backside, close brackets. I'd suggest the second option. I doubt housing will be able to come up with this themselves because they seem to be confused by big words. You could put the second option into the sub and see if anybody shouts. B. Now, two questions about that text there. First, on the sprinkler issue, what was the basis on which you said it would be essentially pointless to try to raise awareness of the coroner's recommendation with all landlords?
I'm trying to think back to that time. I think probably the point is because all of those landlords would have been aware of those points anyway. And as I recall, in relation to the retrofitting of sprinklers, the coroner's recommendation was that landlords should consider retrofitting sprinklers, which I think is something that had been raised with landlords on a previous occasion. So I think I guess that's the point I'm making here, is you'd need a communications exercise to say, please think about this thing, knowing full well that they'd only recently thought about that thing and they couldn't afford it last time, so they probably can't afford it now. I think that's the point I'm making.
Did it not occur to you, though, that landlords, as a group, might take it a little bit more seriously if your asking them was as a result of your following a recommendation made by one of Her Majesty's coroners as a result of an inquest into 6 fatalities?
So I think the challenge for the department is that the department would not be able to make a. This is a nature of the way that sort of government policy impacts on something like this. It's one thing for the department to say, take note, the coroner made this comment which is addressed to yourselves. What the department couldn't do is put any more weight to that, because that would be what would be known as a new burden, certainly on local authorities. So there was a principle which applied in government policy and still applies today, which is where if a government department says to a local authority, you ought to be doing this extra thing, then it is for that department to find the funding for that extra thing. And so for a situation like this, it's one thing to say, we really think you ought to think about this. If you gave any more weight to that, other than essentially repeating the coroner's words, then that would be caught by this, it's known as a doctrine. I think it's a legal term. I'm not quite sure why that's used in the civil service, but the new burdens issue would have been triggered there. So I think that was the difficulty for the department with this, is saying something more direct would have created a funding problem for the department.
The second question relates to the second bullet point. The private comment to Louise Upton that you only have a duty to respond to the coroner, not kiss her backside, discloses, do you agree, your attitude to the coroner's recommendations, which would not tend to indicate that they were being taken very seriously? Do you agree?
Clearly, it's an informal comment. I think I'm describing that second option as the statutory situation was that under the coroner's rules, I forget the legislation, the department must respond within a fixed amount of time, but there's no requirement on the department to do what the coroner recommends. That's for the Secretary of State to consider. So that's the point I'm making here. As you say, it's an informal comment between colleagues, and there's no more than that as far as I'm concerned.
Right. I mean, I think you understood that at the time there was a statutory requirement under the coroner's rules for the department, for the Secretary of State, to provide a formal response.
Yes.
Yes. Now, this letter was addressed to the Secretary of State, not this email, of course. The letter, the Rule 43 letter, was addressed to the Secretary of State. Was it your understanding that the ultimate responsibility for deciding on the terms of the response, including whether the particular recommendations were accepted or rejected, would fall to the Secretary of State?
Yes, and I think the first line in this email, which is probably the one which is that, having seen what colleagues at Housing had drafted, they didn't actually. When you're giving advice to ministers, you need to give them some firm options, recommendations, and I think the draft that Mrs. Upton had sent to me didn't include a recommendation. So the response from the Housing Directorate back to the Secretary of State would have been, "We'll need to consider this," which of course was a fact anyway, and that's the point I'm making, is that you need to actually identify what the options for the Secretary of State are, which is either to actively alert people to the coroner's comments. I can't imagine there was a local authority housing department that wasn't aware of this inquest, or make the point that it had already been raised, which it had been not long before that.
I'm sorry, I'm not sure I follow or really understand that answer. I think the answer to my question is the question whether a particular recommendation is accepted or rejected is one which falls to the Secretary of State.
Yes.
Yes. And in doing that, in accepting or rejecting a recommendation, the Secretary of State at the time would, is this right, rely on the advice of his or her officials?
To some extent. I mean, the Secretary of State, I mean, it's not unusual for ministers to reject the advice they get from officials.
No,
But-
all right.
but so-
I mean, they wouldn't do it without consulting their officials.
It's been known, but generally, yes, you'd
Right.
expect the minister to go back to officials. But what you need to do in that advice is to say, well, these are the implications of the options that are available to you, and I can't remember the detail of this note, but certainly the challenge for the Secretary of State at this time would have been to say anything more than, I hope you're all aware of what the coroner said last week, would be a significant funding issue.
Well, do you agree that in order for the Secretary of State, for the department, to take the recommendations seriously, as you say was done, and for appropriate action to be taken in response, it would be necessary both for senior officials and for the minister, including the Secretary of State, to do two things? Do you agree? First, understand in full the recommendations which had actually been made. Yes?
Yes.
Yes. And secondly, have a clear idea of the nature of the criticisms made by the coroner of, in this case, the approved document.
Well, it's not in the case of this email. This email is about sprinkler provision.
No, I'm asking you a general question.
Oh, I see. Yes.
Yes. So, I mean, I can put it more colloquially. In order to know what to do properly by way of taking seriously this Rule 43 recommendation, senior officials, ministers and the Secretary of State would need to understand the recommendations and have a clear nature of the idea of the criticisms made by the coroner. Yes?
Yes.
Yes. Now, thank you. Let's go to paragraph 22 of your statement, please, page 8. You say there, when the department received the Rule 43 letter from the coroner with conduct of Lacknell House inquest, the recommendations that were relevant to each policy team were identified, and then policy advice was submitted to the relevant junior minister. When ministers were content, the advice was then consolidated and passed to the Secretary of State, who considered the advice and then signed the reply to the coroner. Now, the recommendation relevant to you and your division was the recommendation I read to you, the fourth one, wasn't it, which related to building regulations and approved document B.
Yes.
What steps were taken between the two events that you've identified in paragraph 22, the first being identifying the recommendation relevant to your area, and the second being the submission of policy advice to the minister?
My recollection is it was something that was discussed within the division, so that would have been myself, Mr. Bird, Mr. Leadsom, where we discussed those recommendations, and essentially what the coroner was asking us to do was what we were expecting to do at the next review of approved document B anyway, which would be to apply the new approach to drafting and improve the quality of the guidance. It's something that we were trying to do to all the approved documents.
Now, sorry.
And
So sorry.
I think having identified, having looked at that, I think as a team we took the view that we were in the middle of another project at the time, and I think we probably presumed, I guess wrongly, that we'd be starting work on a review of approved document B quite soon at that stage, within a year or two, I guess, and so it made sense to us to carry out those, implement those recommendations as part of that review, and that would have then been discussed by that general, approach, sort of proposed response would have been looked at by all the way up the department, so directors. I'm pretty sure. I think there were 3 directors involved in this. I'm pretty sure they discussed it, and then that would have gone up the line via directors general, and I can't imagine that the permanent secretary didn't look at this. It's quite an important thing for the department.
Now, the first ministerial submission relating to the recommendations involving your department was, do you remember, sent to you, to Don Foster, who was the junior minister at the time with responsibility for the building regulations?
Yes, he was the junior minister that I would have gone to first, yes.
Yes. If we need to, we can look at it. Let's have it up anyway. CLG 401871. You sent this on the 11th of April direct to Don Foster, yes?
Yes.
Yes, copy to the Permanent Secretary and secretaries to all ministers. Now, this is a very short period here between the receipt by the department of the Coroner's Rule 43 letter on the 28th of March 2013 and 11th of April. Now, during that time, that period, were you the one primarily responsible for formulating the advice to be given to Don Foster?
I was the one with the task of drafting the submission, but its content would have been discussed with a range of officials. Right.
So who else was involved in formulating the content of that advice? Was there anybody else other than you?
Definitely Mr. Bird and Mr. Leadsom, and as I say, the content would have been this would have been cleared at director level as a minimum.
You say definitely Mr. Bird. I think Mr. Bird had actually left the department
I beg your
in
pardon.
January of 2013 and been replaced by Richard Harrell. Am I right about that?
Yeah, I beg your pardon. It would have been Mr. Harrell at that stage, I think.
Okay.
Yes.
How did you and Mr. Harrell and Mr. Leadsom go about formulating your policy advice in relation to each of the 3 matters we've looked at together that the coroner had asked the department to address?
I think this was an exercise that was carried out internally within the department. The time available in order to produce the draft was quite limited, because you've got there's a statutory timetable about which you've got to respond to a coroner's letter, and given that this would need quite a lot of clearance, that meant that, if you like, at the ground, we needed to move quite quickly, because we need to produce some guidance, produce some advice, which would then be cleared through the various hurdles and then through the junior ministers, and then the Secretary of State would need sufficient time to consider if he was happy to sign it. So that meant that we had a relatively short amount of time to do our bit, if you like. So we looked at those recommendations, considered them in the light of what we knew, and came up with what we thought was the best approach. And as I'm aware that directors met to discuss the approach that we were taking. I can't remember when that was, though.
Now, have you read the department's opening submissions to this module of the inquiry?
I have done, yes.
Yes. Let's go to that at CLG 3036387. What I want to do is just show you some of these passages and see if you agree with them. Can we go to page 36 first of all, please? Page 36, paragraph 112A to E. And in that paragraph it says, having given extensive consideration to the response to the Lacknell House Coroner's recommendations issue, the department's position is that A, the department's response to the coroner was inadequate and should have clearly set out whether each recommendation had been accepted, to what extent, and any relevant reasoning. B, in particular, the department should not have worked on the basis that recommendation 4 related to the 2000 and not the 2006 version of ADB, nor should it have concluded that the exercise to clarify and simplify ADB in its 2006 iteration was not safety critical and therefore not urgent, without making that position clear in its response to the coroner and thereby affording her an opportunity to comment on a fully informed basis. C, without having made its position clear in response, the department should have treated the work to clarify and simplify ADB as an urgent priority, and so should not have decided to fold the work into a broader review expected to take at least another 3 years. D, subsequent delays to the original timetable should have been highlighted to ministers and led to a reconsideration of whether changes to ADB required more urgent progression. And then over the page at E, the department missed the opportunity to look beyond the recommendations made by the coroner and to consider how widespread the use of non-compliant materials on high-rise residential buildings was and the associated fire risks. Now, we can take each one in turn, but let me ask first, generally, do you agree or do you disagree with any of those admissions?
I disagree with some of them.
Right. Now let's go to the previous page, please, page 38. Do you disagree with A? Let's go back, page 36. Sorry, page 36. Do you disagree with A?
To some extent, I think my concern, as I said to you yesterday, I've had no involvement in the drafting of this document at all, which is probably appropriate, I guess. Practically everybody, the whole line of the department at that time considered this response. This isn't something that was cooked up by a few junior officials and handed to the Secretary of State. I think if it's the department's view and perhaps the government's view that in future, or this coroner's letter and any other coroner's letter should be responded in a specific way, then it needs to issue guidance at cabinet level to all departments as to how coroner's letters should be responded to. There is no such guidance in place at the moment, as far as I'm aware.
Well, my question is, do you agree or disagree? It sounds as if you disagree.
I think I do disagree. I think
right.
At the time, we considered the coroner's letter and drafted what we thought was an appropriate response. And two ministers, I guess, junior ministers and the Secretary of State were all satisfied that it was appropriate. So I have an issue with that.
Okay. Do you agree that it should have clearly set out whether each recommendation had been accepted, to what extent, and any relevant reasoning or not?
I thought it did to a reasonable degree, but I can see how people would argue differently in hindsight, and I think that's the point I'm making. Is if genuinely the department and the government thinks that that coroner's letter should be responded to in a particular way, then that should be something that's set out in guidance that applies to all government departments, and that from the Cabinet Office.
Looking at B, is there anything in B you disagree with?
I think I do. I think the department's response to the coroner's letter set out a timetable along which it was planning to bring into effect those recommendations, and that made it clear that this was not going to be done very quickly. Now, so I think on that point it was clear that the department wasn't dealing with this as an urgent matter. So I think that's the point I'd like to make about that
Right.
paragraph.
Right. What about C? Do you agree with or disagree with any part of C?
I guess it's linked to B. This question of whether those amendments were urgent or not.
Yeah.
It is we didn't perceive them as being urgent at the time. I guess in hindsight, perhaps one could argue that they should have been treated with more urgency, which is the argument that's been made here. If that was the only way we could have done that at the time, would be to bring a halt to the work that we were doing at the time, and I don't think ministers would have been supportive of that at the time. I think this position paper is the position of the current department, led by the current Secretary of State. We weren't working for the current Secretary of State at the time, so I think it's quite difficult to look at this in this way. Sorry, that's not a very clear answer.
What about D? Is there anything you agree with or disagree with in D?
I think I agree with D in that once the original timetable had started to slip, then that probably should have been brought to the attention of ministers, and the fact that in amongst the programme that had been delayed was a response to a coroner, and I think the problem we had, which I know you discussed with Mr. Leadsom and Mr. Harrell, is that having grouped the Part B review in amongst a much wider review of the whole of the building regulations meant that the references to the coroner's recommendations had slipped to the bottom of the submissions and documents that related to it, and I agree that was a mistake.
And then finally, at the top of page 37, E. Is there anything you agree with or disagree with about that?
I agree with that, and I think in part I'd carry some responsibility for that, in that I think I'd become entrenched in a focus on what do we need to do to approve document B in the future, and did not properly appreciate some of the hazards that might result from materials that were in existing buildings. I mean, this is focused on the Lackner House fire. But I think even in that respect, I accept that I think the department and to some extent myself, we should have said to ourselves, this doesn't comply with our current guidance is one thing, but does it present a sufficient risk that we should be raising it for existing buildings? And I think we were entrenched in the mindset that we were thinking about what do we do next to the approved documents rather than what's the risking the existing building stock?
Thank you. Now let's go back to your statement then, please, at paragraph 25, page 9, where you say you set out the coroner's recommendation there, and looking at recommendation 2, what you've called recommendation 2 in the middle there, which focused on the format and language of the approved document, and in particular on a review to ensure that the document was intelligible to users. Was that recommendation accepted, or was that rejected?
I think it was accepted insofar as was practicable.
What does that mean?
It means we accepted that we needed to try and make the approved documents as intelligible to as many people in the industry as possible, and not just building regulations specialists. I think we accepted that, but as we discussed earlier today, there will always be people looking at the approved documents who might not fully understand it.
Is this right, that the conclusion was in fact that the department already started to plan to update the format and style of the approved documents using the newly published style guide, as you, I think, had told the coroner in your witness statement?
Yes.
If we go to paragraph 26 and go over to page 10 in that paragraph, in the last 4 lines of that paragraph you say, I feel it is important to note that as much as the department was intending to update ADB in accordance with the new style guide, the approved documents should properly remain in the realm of professionals as set out in the Secretary of State's response to the 20th of May 2013. Now, are you expressing your own view there, or the view of the department at the time?
I think that was a view of the department at the time, and that's what was set out in the Secretary of State's letter.
And was that the same view that you expressed to the coroner during your evidence, as we've seen?
I think so, yes. I mean, it's worth noting I've come across a number of people in the sector that have expressed a concern that there's a danger from writing the approved document in such simplistic terms that somebody with no training in construction thinks they can design a building. And I know that's something which a number of people in the fire sector were concerned about, is that you wouldn't want this so simple. I mean, I'm not sure that's actually a possible thing, but I think that was a concern in the sector, that you don't want anybody designing a building. They still ought to be competent people, because you can't possibly write a book that tells you how to design a building. It's something you need to be taught how to do.
Which professionals or categories of professionals are you referring to in your statement here?
I'm not just thinking of building control professionals, I'm thinking of design professionals, so structural engineers, fire engineers and architects, I guess.
Now, the regulations, of course, apply to anybody carrying out the work, don't they?
Yes.
Yes, and that could be an ordinary householder or a builder with no professional qualifications and possibly no experience. Yes?
Yes.
So why should the guidance on how to comply be limited to a smaller class of person, the class that you've identified?
Because the only way you would be able to do that is to write a book that explained shovel by shovel how to build a building, and that's just not feasible.
But was that not rather the coroner's point? She was essentially, wasn't she, rejecting your evidence or your opinion about the class of readership, and recommending that it be made clearer and simpler and easier to navigate for the entire class of readership, namely or including the person carrying out the work.
I'd be surprised if she meant somebody that had no training in construction whatsoever. I can't say that for certain.
Right. Did you think about this at the time? I mean, did you think, how do we marry the need to ensure that it isn't a shovel-by-shovel instruction booklet to the completely uninitiated, on the one hand, but on the other, consider that it is guidance for those persons carrying out the work who are bound by the regulations?
That's something that we, in developing the style guide and talking about the approach to the way we produce approved documents in the future, that was very much on our minds.
Now, before the department received the coroner's recommendations, when was it that the department had been intending to update the style of approved document B? The style, the layout, the language?
I don't think that was fixed in time at that point. So the Future of Building Control document had a plan in it that had been put to one side by the coalition government when it came in replaced by the work that we've been tasked to do and sort of red tape challenge and so on. And I think at the time, ADB was due a review, and this was a catalyst, if you like, to get a date fixed in the diary.
Now, moving on to recommendation 1, if we can turn the page back, please, to page 9, paragraph 25. You've set it out there. It's a direct quotation from the letter. Provides clear guidance in relation to Regulation B4 of the building regulations with particular regard to the spread of fire over the external envelope of the building and the circumstances in which attention should be paid to whether the proposed work might reduce existing fire protection. What was your own understanding at the time of that particular recommendation?
I think to some extent it was a criticism of the bits of the approved document that the inquest had been looking at. So I think myself and my colleagues all took the view that the 2006 edition, at least to some extent, had already addressed some of these criticisms, which is why I think we concluded that we didn't think it was urgent.
Did you understand the coroner to be indicating by these words that the guidance on external fire spread in particular was not clear enough to the reader?
I'm trying to think exactly what we were thinking, and I don't want to put words into our mouth. I can't remember exactly what we were thinking. We came to the conclusion that the coroner was referring to the previous edition. We, in our view at that time, improved that text, and I understand that's a contentious point now. But at that time, we thought that text had been improved, and it made sense to do all of this in a single exercise. We didn't see it as being an urgent issue.
Let's look at this theme as you pick it up in paragraph 26, as you do, because you cover this there to some extent. You say this: the inquest had, as the coroner stated in her Rule 43 letter, been working from the 2000, incorporating 2002 amendments edition of ADB, as this was the guidance that was in force at the time the works were carried out on Lacknell House. However, a new edition of ADB had already been published, and it was felt that recommendation 1 had already been addressed by the revisions made in the 2006 edition of ADB. I sent a submission to Don Foster regarding the Rule 43 recommendations regarding building regulations on 11th of April 2013. The advice was that issuing a new, further clarified ADB would be an extensive exercise and that it would be logical to include this and recommendation 2 as part of a wider technical review. Now, and it goes on to support the submission, etc. Now, if the consensus was that recommendation was, as you say, had already been addressed by the revisions made in the 2006 edition of ADB, is it not right that in 2013 there would have been no immediate or urgent need to review or rewrite that section of the guidance?
I think that's the view we were taking, yeah.
Right. But given that the 2006 edition of ADB predated the Lacknell House fire by 3 years, and the inquest by some 7 years, how could it have addressed the particular problem with ADB that the evidence in the inquest revealed and which concerned the coroner?
Because the coroner was looking at the 2000 edition. So it hadn't the 2006 edition clearly didn't directly address the issues that the coroner had raised because they were drafted before the coroner had raised them.
Exactly.
But
that's the point.
We took the view that the changes that had been made had the effect of addressing those recommendations.
Right, I follow. But does it follow that in fact neither your witness statement to the coroner nor your oral evidence to the coroner actually told her that the 2006 edition of ADB addressed the problems about external fire spread revealed by the evidence that she'd heard?
I guess that's true.
And it explains, doesn't it, why she was left with the impression that ADB 2006 did not provide clear guidance about external fire spread.
That wasn't the impression that I got from her letter.
Why did you not go back to her and, in response, or advise the Secretary of State to go back to her and say, well, the problems at Lacknell about compliance with the 2002 edition have been cured through the amendments to the 2006 edition, and therefore your recommendation 1 has already been met?
I guess we could have done that. That wasn't the form of words that we came up with.
No, but I mean, if you had thought at the time that the coroner had missed the point, and that recommendation 1 was unnecessary, why didn't you advise the minister that he or the Secretary of State write back to her immediately, correcting her and saying, well, recommendation 1 is unnecessary?
That probably would have introduced quite a lot of delays. As I say, we had to turn this around quite quickly in order to meet the coroner's rules.
Why would it have introduced any delays? The Secretary of State could have responded on the 20th of May in exactly those terms. What was wrong with that?
And at the time, we thought that was the right advice to give. We looked at what the coroner had said. We looked at what happened at the inquest and thought about what had been done to the 2006 edition, and also looked at how easily we could go back and do that, revisit those particular provisions, and came to the conclusion that the best advice would be to give the response that we did.
Can we look at the recommendation letter again, the Rule 43 letter, CLG 50401? Page 3, under the second heading. She says in the second line there, I'm aware that ADB has subsequently been amended and believe a further amendment is due to be published soon. So did you spot the fact that the coroner had specifically acknowledged that approved document B had been amended since 2000, but had nonetheless made that recommendation?
I'm trying to remember what we were talking about at the time, which is difficult.
Why didn't you go back to her, or rather advise the Secretary of State through the ministerial chain, to go back to her and say, you've quite rightly picked up the fact that ADB had been amended after 2000 and 2002. It was, in fact, amended in 2006. And as a result of those amendments, your recommendation 1 is no longer necessary.
I guess we could have done. That's not the approach that we decided to take.
Did all the officials involved in this discussion leading to the formulation of policy advice on this recommendation agree that the coroner's recommendation in recommendation 1 had been comprehensively addressed by the amendments made in 2006?
Certainly within our division that would have been the case, because we would have looked at it and talked it through.
Right.
I think above that level, I imagine the directors would have just would have just looked and decided, is this an appropriate response to a coroner, which they clearly decided that it was. I doubt they would have read the approved document.
In what way specifically did you at least consider that the revised 2006 edition of the approved document had already addressed the recommendation?
We thought at the time that the way we'd restructured the guidance on B4 made it more straightforward. I can see why people would dispute that now, but that's what we were thinking at the time.
I think it's right that your decision was to advise ministers not to attend to this recommendation straight away, but to address it as part of a wider technical review alongside recommendation 2.
Yes, I mean one of the problems, if you're trying, and I've had experience of this on other projects, is where you take technical guidance and you say, can we make this easier to use? If your terms of reference are that make it easier to use but don't change any of the technical provisions, that becomes very difficult sometimes, because sometimes the technical provisions are just complicated, and we'd certainly had that problem. The work that we'd done in relation to staircases, where I think it was mostly led by Mr. Harrell and Mr. Kelly, but certainly I had quite a lot of involvement in that as well. We'd come across a number of points where we said, I'm not really sure how to make this clear. It's the text is problematic, the table makes no sense, or whatever the problem was. But to change that without making some sort of technical change would be very difficult. And so it would be better to have the option in your terms of reference to make technical changes as well as just structural changes to make it easier to follow. And that's one of the reasons why we felt it was better to do that. We had the same problem immediately after the Grenfell fire, when the Secretary of State asked us to carry out this exercise, and had a considerably bigger team to do that with. And we came across a number of points working with various stakeholders in the working groups that we were working with, that there wasn't an easy way of simplifying something without fundamentally changing that technical requirement, and that would have been out with the terms of reference that we had, and so we had to park some of those problems and move them forward into a technical review. So that's why we felt carrying out a clarification and improvement exercise, an editorial exercise, if you like, without having the option to make technical changes, was not an efficient way of working.
Was that recommendation accepted or was it rejected?
Which recommendation, sorry?
Well, the recommendation to, not to address the recommendation immediately, but to address it as part of a wider technical review. Was your advice accepted or was it rejected?
That was accepted.
Was the recommendation at 1 accepted or rejected? In other words, the recommendation in the first bullet point there.
The coroner's recommendation
Yes.
you're talking about now?
Yes.
Um,
Was it accepted or was it rejected?
It was. I guess it was accepted. I can see the point in that the letter doesn't categorically say accept or reject. I'm not sure if that's necessary. If government thinks it is necessary, then that should be a matter of policy and not something that's left to individual departments to consider on a case-by-case basis.
Well, let's go to CLG 3011293. This is the submission from you to the then Minister Stephen Williams on the 11th of June 2014. Now, this is a year on after the Secretary of State's 20th of May 2013 letter back to the coroner. And at paragraph 3 there, you say, under background, following the Lacknell House fire, the coroner criticised the complexity of the guidance in approved document B and called on the government to revise it. The Secretary of State rejected this C flag B, but did commit to a review which would deliver a revised document in 2016/17. Preliminary work is now underway. Now, flag B is simply a copy of the Secretary of State's response to the coroner's recommendation letter. Okay, so it looks as if, in fact, the Secretary of State rejected, or was understood by you to have rejected that first recommendation. Is that right?
I think it's a bad choice of words. Looking back at this, I think the point we were trying to make was that we accepted that the approved document should be improved and had plans to do so. What the Secretary of State rejected, I guess, was that this needed to be done immediately. I think that's a bad choice of words in this submission.
Mr. Chairman, I've got a little bit of a way to go before we finish this major topic, before moving on to another section. If I was to have another 10 minutes, I could finish a subsection of it. I'm in your hands as to whether we go on this evening a little bit later or not. But the answers are quite long at the moment, and
Yeah, well, Mr. Martin's probably getting quite tired. It's been another full day, and we're going to have to ask him to come back tomorrow.
we are. We're going to have an imposition anyway, because we have a Secretary of State giving evidence in
but
the
if
morning.
we stop at this point, is it going to put us in difficulty finishing his evidence tomorrow?
That depends on the alacrity with which Mr. Kinnear asks his questions and receives his answers tomorrow morning. But the answer is yes, it might. It might endanger whether we finish Mr. Martin tomorrow.
Right.
If we were to take another 15 minutes, again, no guarantees, but I would be closer to be able to be confident.
Well, you've heard that exchange, Mr. Martin. How do you feel about the afternoon? Has it gone on too long for you already?
I suppose the honest answer to that is yes, sir. But I think if an extra 15 minutes will help the inquiry, then I'll do my best to continue.
That's good of you. I think the alternative, which you might prefer, I don't know, might be to take the chance of having to sit a little bit late tomorrow, because we'd like to finish your evidence tomorrow, and I'm sure you'd like to finish tomorrow as well.
Yes, sir.
Would you rather take the chance of going on tomorrow?
Either is equally.
Well, except that you won't have given up. I'm afraid, as I was going to explain to you, we won't be hearing you first thing in the morning. So it'll only be a half day tomorrow.
I suppose in terms of my ability to give you my best answers, then I guess working late tomorrow is probably the best option.
The better option, yeah. Mr. Millett, I'm loath to interrupt you partway through a topic, but I think the day has been quite long.
Very well.
And Mr. Martin will not be giving evidence first thing tomorrow, and so he will be, to that extent, fresher
Yes,
If we have to sit late tomorrow to finish him, well, maybe we have to.
very well.
But I think that's probably the better
Yeah, very well.
choice.
Yeah. Thank you. All right.
Can you just help us with this? At what time would we like to be able to continue Mr. Martin, depending on the next witness?
2 o'clock.
So if we ask him to come for 2 o'clock, that'll be all right with it.
Yes, I'm hoping that it won't be later than that, but I'm...
Well, it won't be earlier, that's the
It
point.
won't, no, I don't think it will be earlier than that.
All right. Thank you very much. Well, Mr. Martin, we have to interpose another witness tomorrow morning because one of your former ministers is coming to give evidence, and he will be abroad at other times that we might have seen him. So we're going to have to put him in at 10 o'clock tomorrow morning. The expectation is that he will complete his evidence during the morning. So we're going to have to ask you to come back, but not before 2 o'clock, please. Can't promise you'll actually start at 2 o'clock, but we'll do our best to make sure you do. And then we'll reckon to finish your evidence tomorrow afternoon, even if we have to sit a little bit late to do that. Is that all right?
Yes, sir. I've worked with enough ministers to know that Secretary of State's diary is not something to be messed with lightly. So
Well, we've said we'll take him tomorrow, and I think we have to do that. So
Yes, sir.
we'll break at this point. As I said, I'm afraid we have to get you back again tomorrow, but if you could be here ready to start by 2 o'clock, we'll take you as soon as we can and expect to finish your evidence then tomorrow afternoon.
yes, sir.
And in the meantime, please don't talk to anyone about your evidence or anything relating to it.
I understand.
All right?
Yes,
Thank
sir.
you very much. Well, then we'll break there and we'll see you in time to start at 2 o'clock tomorrow. Thank you very much. Mr. Bennett, I'm sorry to interrupt your questioning at that particular point, but I think it's been long enough, Mr.
Yes.
Martin, and
Yes.
we'll sit as, I won't say quite as late as we have to, but I think that ought to be the
That's very good.
in order to finish him.
Yes.
But please bear in mind that although he's starting late, by the time we get to 4:45, everyone's concentration is beginning to,
Indeed. And I'm thinking of the transcriber's fingers.
well, the transcriber's fingers, yes, a very important part of the whole operation. We have to bear those in mind.
Yes.
And if you think we're going to go quite late, could you let us all know?
Yes, of course.
We'll think about whether we need to take an additional short break.
Yes, that's very helpful. Thank you very much.
Right.
Yes.
And then tomorrow morning we have a different witness at 10 o'clock.
We have Brandon Lewis.
Yeah. Good. Thank you very much. Well, we break at that point and we resume at 10 o'clock tomorrow morning, please. Thank you very much.